Joe Richardson, civil rights attorney at McCune Law Group, getting into it once again, breaking it down, the law and common sense.
Was this first-degree murder or a killing done in the heat of passion? A verdict is being read right now in an Iowa courtroom by a judge in the case against Nathaniel Bevers McGivney. We're picking it up where we left off with the judge reading the verdict that he has for this defendant. Let's go in.
Against another, resulting in death, the fact finder may, but is not required to, infer that the weapon was used with malice, premeditation, and in specific intent to kill. On September 22nd, 2024, the defendant went to Farnhamville City Park armed with a knife. The defendant approached Michelle Jackson and cut her throat with a knife, and then proceeded to stab her in the back until the blade became detached and remained lodged in her back. The defendant then continued to stab Michelle with the handle and base of the knife. Prior to cutting the throat of Michelle, the defendant had the opportunity to deliberate on his decision, and his ultimate decision was to attack Michelle with the specific intent to kill her. The defendant's attack was premeditated, willful, and designed to do physical harm to Michelle Jackson. After considering all the evidence submitted in this case, the court is convinced the defendant is guilty beyond a reasonable doubt of count 1, murder in the first degree. Regarding count 2, the court finds beyond a reasonable doubt that on or about September 22nd, 2024, in Calhoun County, Iowa, the defendant hid Michelle's corpse. The evidence established that the defendant dragged Michelle's body through the park, then retrieved a rolling trash bin, put her body in the trash bin, moved the bin a significant distance from the park, and left the bin near a cornfield. The court is convinced beyond a reasonable doubt the defendant hid the corpse of Michelle with the specific intent of concealing the crime of murder in the first degree. The evidence demonstrated that the defendant attempted to move the corpse soon after the murder and attempted 2 different methods of moving the body: dragging the body and placing the body in a rolling trash bin to move it more easily. This duality of methods of moving the bodies, as well as the significant distance the defendant ultimately moved the body, demonstrates his specific intent to conceal his crime. After considering all the evidence submitted in this case, the court is convinced the defendant is guilty beyond a reasonable doubt of the offense of count 2, abuse of a corpse. Verdict in order. The defendant is found guilty of count 1, murder in the first degree, a Class A felony in violation of Iowa Code Sections 707.1 and 707.2, sub 1, sub A, and count 2, abuse of a corpse, a Class C felony in violation of Iowa Code Section 708.14, sub 1, sub B. It is ordered that sentencing is set for August 15, 2025 at 10 o'clock a.m. in the District Courtroom of the Calhoun County Courthouse in Rockwell City, Iowa. The defendant shall be held without bond. Defendant is advised of his right to file a motion for new trial and motion and arrest of judgment pursuant to Iowa Rules of Criminal Procedure 2.24 sub 2 and sub 3. To be considered by the court, said motions must be filed no later than 45 days from the date of this verdict in order, and at least 5 days before the date set for sentencing. The Department of Correctional Services shall prepare a pre-sentence investigation report pursuant to Iowa Code Sections 901.2 and 901.3. Is there anything further from the state? Anything further from the defense?
Your Honor, Class A felony, I think the code specifies that they don't prepare a PSI on that. I know there's a second counter that's a D felony, but...
I ordered it because of the Class C felony conviction. I was aware of that as well, but that's why I ordered it. Any comment from the state?
Yeah, I've never dealt with where you have any amnesty. I think, I presume that the reason for the, even from the A's is that it's going to be there and it'll have all the time they want to assess, and plus the court will have discretion in sentencing. Maybe correctional services will challenge if they don't want to do it.
I think it's possible, considering that there is a chance that a motion for a new trial, or a motion may be filed and you may change your mind as to one or the other.
That's fine. We keep it as set, and then we'll address it where fine immediately for the finals.
All right. Then I will leave it as is, and with that, we are adjourned.
And that ends the bench trial for Nathaniel Bevers McGivney, found guilty as charged. First-degree murder, the top count there in Iowa. It carries a mandatory sentence of life without parole. Let's bring in our guest who is standing by watching this with us, civil rights attorney and law professor Joe Richardson with us. And Joe, this was a difficult case for the defense to try and argue, but they tried to lean on the senselessness of this, the fact that there was no connection between this defendant and the victim in this case. He left his earbuds behind. They claim that that made this clearly a spontaneous outburst. But how do you think the prosecution did in terms of clearly convincing a judge that this was first-degree murder?
Well, clearly they were successful, and they had a lot to work with here. You know, a lot of folks don't always know that, you know, there doesn't have to be a specific length of time in order for premeditation to be shown. They just have to form the intent and have time for reflection, time to do something different. And then if they go forward, you know, then it's this deliberate act as opposed to something that it's impulsive. And so the judge decided, based on what it was he saw factually, is that he had time to reflect on that, and that there was a deliberate intent to kill. Again, it doesn't take long, doesn't have to be weeks and months. The defense wanted to say, well, he does this, it's impulsive, somebody he doesn't even know, so he's not forming intent. Why does he want to kill her, et cetera, et cetera, et cetera? They tried to use the fact that they didn't know her, he didn't know her, as suggesting that this couldn't be deliberate, that this would have to be impulsive because it just didn't make any sense. The judge just didn't buy it.
Absolutely not. And he was clear in his ruling on the reasons why he wasn't buying it. We just saw images of this family being let out, leaving the courtroom, hugging each other. No doubt, just a heart-wrenching process to go through. But Joe, they are heroes in this case. I mean, they are the ones who found this suspect, confronted him, held him at gunpoint until police were able to take him into custody. I mean, this case, senseless really is the word, because there really is no motive. The only offering this defense made in their closing argument was that though they knew it wasn't a legal defense, that he has some kind of childhood trauma in his past, and they said they know it doesn't justify, but it could give some explanation or motive. Your thoughts there?
You've got a girl that likes to swing at the park, and that's supposed to be a safe place. And so this is a violation of the highest order, a violation of safety. This is not a tragedy that accidentally took place. This is not a car accident where somebody took a wrong turn or something like that. This is something that is absolutely senseless going on against somebody completely and totally innocent. And so hopefully, you know, you'll never be the same because you lose a family member, but fortunately the family, you know, was there, or members of the family were there to kind of rein him in once this happened so that they could start on the road to justice. You never be the same. It's not something you get over. You try to get through it. But at least they will have some semblance of closure. You don't always get closure, as it were, and we don't know how satisfying it will be, but this is the best definition of closure they could possibly have, to have the person that they know actually committed the crime, actually suffering a punishment that is the biggest that the law would actually allow. And that's about the best you can do.